Defendant Tony Robinson appeals the summary denial of his petition for extraordinary writ on the ground that it was successive. Robinson had alleged in his petition that his 3 convictions for resisting an officer with violence were illegal because his offenses occurred during one criminal episode, and that his 6 5-year sentences as a habitual felony offender for battery on a law enforcement officer and resisting an officer with violence should run concurrently rather than consecutively, also because the offenses occurred during a single episode. The trial court did not address Robinson's first issue and denied the second because he has filed 4 previous motions raising the same issue. We affirm the summary denial of Robinson's first issue because it is time-barred. We reverse the denial of the second issue and remand with directions for the trial court to consider the merits of Robinson's claim. Robinson's convictions become final on March 24, 1992. If the record were to show that his offenses occurred during a single incident, his first claim that he should have been convicted of only 1 count of resisting an officer with violence rather than 3 would be correct under Wallace versus State. In response to a complaint about a prowler, sheriff's deputies searched without finding anybody until they came upon the defendant an hour and a half later walking west along a road he could have reached from the neighborhood they had searched before. It is further alleged that on seeing the sheriff's deputy's car, he turned and began walking east. When the deputy got out of the car and indicated he wanted to speak to him, the appellant turned around again and started west. At this point, the trial judge concluded there was reasonable suspicion justifying stopping him to ask for identification. We agree and affirm. In denying the motion to suppress, the lower court found, 1, that the initial stop of defendant was a valid Terry stop, and 2, that the evidence was properly seized incident to an arrest for obstructing a law enforcement officer pursuant to Florida statutes 1999. In my judgment, the first finding was erroneous as a matter of law and requires reversal. And because the initial stop was illegal under Terry, the false identification which appellant thereafter gave to the detaining officer could not form the basis for an obstruction charge. See Forner versus State. The court recited the following facts justifying its conclusion that the officer's impediment to defendant's freedom of movement was a valid Terry stop. The fact that the officer had received a report of an earlier prowling incident did not give rise to founded suspicion justifying the later stop and detention of Sinclair. A report of criminal activity in the area will not justify a stop absent circumstances which create a reasonable suspicion that the person being stopped has participated or will participate in the criminal activity. Smith against State. Denial of a motion to suppress was reversed on facts showing that before the detaining officer stopped the defendant, he had received information that there had been an unusual number of burglaries on a particular street, and the officer thereafter saw the defendant's car in the evening parked on the grounds of a business that was closed. To the same effect, see Moore versus State, 584 Southern Reports, 2nd, 1122, Florida, 4th Circuit, 1991. Mack versus State, 557 Southern Reports, 2nd, 905, Florida, 2nd Circuit, 1990. And Jordan versus State, 544 Southern Reports, 2nd, 1073. Florida, 2nd Circuit, 1989. Moreover, the fact that defendant, after being approached by the officer, walked away from him at a pace faster than he had been initially seen walking does not justify his detention. Avoidance of a police officer does not give rise to a founded suspicion to justify detention. See McLean versus State, 408 Southern Reports, 2nd, 721, 722. Defendant's conduct, taken for its most insidious implications, indicated only that he wanted to avoid police and did not provide reasonable suspicion of criminal activity. The majority cites Illinois versus Wardlow, 528 U.S. 119, 120, Supreme Court, 673, 145 U.S. 2nd, 570, 2000. Yet that case was decided based upon facts that are absent in the instant case. Good.
That was pretty slow. I did fine.
120.